Introducing My Hoover. Through this new feature, you can now more easily follow the work of your favorite fellows and policy topics. Customize your newsfeed, manage newsletter subscriptions, and receive notifications when your favorite publications, broadcasts, and podcasts go live. Bookmark articles, essays, and multimedia for later viewing. Take the step to create a My Hoover account now and transform the way in which you acquire this valuable knowledge.
Between now and the spring, the Supreme Court will rule on at least 3 cases involving Donald J. Trump. 2 questions. What should the court rule, and what will it rule? Richard Epstein and John Yoo on Uncommon Knowledge now. Welcome to Uncommon Knowledge. I'm Peter Robinson. Richard Epstein is a professor of law at New York University, a professor of law emeritus, and a senior lecturer at the University of Chicago, and a fellow here at the Hoover Institution. John Yoo is a professor at the University of California, Berkeley Law School, and like Professor Epstein, is a fellow here at the Hoover Institution. Professor Yoo served as Deputy Assistant U.S. Attorney General in the Office of Legal Counsel during the administration of President George W. Bush. I should note that Richard and John are old friends, having appeared together for more than a decade now on Law Talk, the Hoover Institution podcast. Much of the time they agree, but when they disagree, it is King Kong and Godzilla.
I'm Godzilla.
I was wondering.
He's King Kong.
Okay.
I'm Fay Ray.
All right, boys. Will you pipe down now? Each one of these requires a bit of a setup. I have to explain the case, but then off you go. Trump versus Anderson. Here's the background. Last December, the Colorado Supreme Court ordered former President Trump's name removed from the ballot of the Colorado Republican Party, which will hold its primary election this coming spring. The basis for that ruling, the events of January 6, 2021, the Colorado Supreme Court held A, that Trump's actions before and during the attack on the Capitol amounted to insurrection against the United States, and B, that the 14th Amendment, this is the amendment ratified in 1868, that the 14th Amendment disqualifies anyone who has engaged in an insurrection against the United States from running for president. Donald Trump appealed the Colorado Supreme Court's decision to the United States Supreme Court, and as we sit here, just last week, the court announced that it would take the case. We're recording this program in mid-January. The court will hear oral arguments on February 8th. Former federal judge Michael Luttig, long considered a leading conservative and originalist, quote, Section 3 of the 14th Amendment simply could not be any clearer that the former president is disqualified from the presidency, just as the Colorado Supreme Court held. John Yoo?
What?
What should the court rule? Is Luttig right? Is this
wrong.
A slam dunk?
No, this is not a slam dunk. It's a close case. In fact, 2 very distinguished originalist scholars were the ones who came up with this idea that you could disqualify a president under the 14th Amendment, Section 3, which is written right after the Civil War, and of course is primarily aimed at the people who joined the Confederacy, but not limited to the people who joined the Confederacy. I think that the U.S. Supreme Court will quickly overturn Colorado. I think we're going to see light speed in terms of how fast that opinion comes out for several reasons. One, I don't think that the founders, the people who wrote the 14th Amendment, and I certainly don't think the Supreme Court will think that there should be 50 different states all interpreting the 14th Amendment differently, all applying their own standards.
Since this Colorado Supreme Court decision, the Maine Secretary of State took it on herself to kick Trump off the ballot. So this is...
And you've got 3 other state Supreme Courts saying, no, Trump isn't disqualified
including
under
California,
the
by
ballot.
the way. Yeah.
California's Secretary of State. So if you think about what the kind of disorder and chaos that could arise if each state is allowed to say, we're going to choose our own disqualification standards and we're going to start kicking people off the ballot. It's also not just the president you're talking about. You're talking about people who run for Congress, for Senate, members of state houses. The list of officials this provision applies to long. So that's what the second thing is. I don't think the provision applies to the president. It doesn't say the word president. It doesn't seem to apply to people who were president, who might have engaged in an insurrection, and it doesn't seem to prohibit people from running for president. So I think there's really two strong grounds that the Supreme Court
But one of them
can
is pure
use.
policy prescription. I'm forced to point out, Professor Yu.
Policy.
You're saying that the Supreme Court won't permit this to stand because it wouldn't work well.
Well,
that's
but
not a legal argument
No,
at
no,
all.
but that's a legal argument because that is one of the reasons why you have a single Supreme Court to impose a uniform interpretation of the Constitution throughout the country.
Okay, I'm coming to you in just a second, Richard, but first listen to this. Adam Liptak in the New York Times. The point here is that this case is even bigger than it sounds. Quote, "The sweep of the court's ruling is likely to be broad. It will probably resolve not only whether Mr. Trump may appear on the Colorado primary ballot, but his eligibility to run in the general election and to hold office at all." Close quote. We have a number of polls over the last few months in which Donald Trump leads Joe Biden. Yeah, I just looked at a poll, ActiVote poll, the other day where Trump leads Biden by 8 points. Now there are other polls, but in some polls he's leading. Is it conceivable that the Supreme Court could choose to tell Trump voters in their tens of millions that the final decision about whether Donald Trump may or may not run for president sits with the court and not with them?
No, it's not conceivable.
It's not.
The question is how you reverse this situation. And there are many grounds that you could use, but there's only one that works. What you must do is to simply say that this is an issue which is a political question and the courts have nothing to do with it. Let me sort of elaborate on some of the things that John said. Right. You misstated the problem when you gave it to us. You committed legal malpractice.
Well, it's not the first time.
Nor is it the last time.
And not for the last time. I'm thinking to myself, not for the
But you
first time, I'm
said-
thinking to myself, thank goodness I don't get a grade from Richard at the end
Well,
of this.
I mean, but what happened?
He has a grade for you. He's just not telling you what it is.
Well, no, but this is a common mistake.
All right.
What that you just said is that it disqualifies any person from president for an insurrection, right?
Right.
That's not the way the amendment reads.
But that's what the Colorado Supreme Court
I know,
held.
but they made a very serious make.
well, at least
I mean, what you do is you have to start with the beginning of the provision, which says when you're talking about a senator or a representative or a presidential elector, they are going to be subject to this. And then there's
And that's clear in the language of the
Yes,
amendment.
that's what they say. They don't mention the president, but they mention the presidential electors. So the first question you want to ask, is this just an omission that somehow they didn't think of it? No. What they were trying to do is to make sure that any state official coming from the South would not be corrupted by the various sorts of insurrection. So what they did is they went after the members of the Electoral College because those are chosen on the state level. And if it turns out you get all of the insurrectionists or rebellion people out of the thing, then when you run the Electoral College, you have the right bunch of people and they will make the right kind of decision. And so
They didn't want a bunch of former Confederate officers
determining who would
in
be
the
the
Electoral College choosing the next president.
But if they're
Is that
not
what it
there,
comes down
yes.
to?
And if they're not there, then you have a perfectly normal electoral college and you let the political provisions go. Ludig is very irresponsible on this because they never take these words into account. So that's a first problem. The second thing is there is a very technical decision that is hinted at by John. There's one thing to talk about the president having an officer, and there's another thing to talking about the president being an officer. Office versus officer. The R makes all
Office
the
versus officer.
Yes.
All right.
The R makes all the difference because if you then look at the Appointments Clause of the Constitution, it says that all people who are appointed as officers have to be appointed by the president. And so what you do is you're saying if the president is an officer covered by this clause, it means that the way he gets chosen is in fact to appoint himself as president. And so what Michael Mukasey said some time ago
Michael
is...
Mukasey, former Attorney General, and a very fine lawyer. as far as I can tell,
What he
in his
said
own
is
right.
that, look, he said, if you look at the remedial provision, Congress has the veto power that it can waive. You know, 2/3 of the people say you could do that. And what it clearly is, this is about appointive offices because that mechanism could not possibly work for the president who's chosen through a very different system on the Electoral College.
So the court will say, we want nothing to do with this.
And
it will decide it on such narrow grounds that it will come down to the letter R.
Well, and now it won't come down to that. There are lots of other things, but yes, it's an important...
But they'll choose the narrowest ground
Well,
possible because the Chief Justice wants everybody on board, correct?
Hopefully it would be a unanimous decision. I don't expect it would be, but that would be ideal. And this would be, in a way, democracy enforcing because then Trump stays on the ballot and the people can decide.
get to decide.
The one thing about going the other way, and I agree that I can't see the court upholding Colorado because it wouldn't just be upholding Colorado. For it to uphold Colorado,
Every
the
other
Supreme
state.
Court, the Supreme Court have to
takes them
say,
off.
not only is this something we can decide, not only does it apply to the president, but we also have to find Trump engaged in an insurrection on January 6th. And so the Supreme Court would actually remove Trump from the ballot in all 50 states.
Yes. That's
I
lip
can't
text
see that
in the New York
happening.
Times.
Yeah,
Yeah,
so
I can't
that's-
see that happening.
It's not going to happen.
All right, and you said you expect a decision with lightning speed.
Yes.
Colorado holds its primary. The Republican Party in Colorado holds its primary on March 5th, which is Super Tuesday. It's a big day in the electoral.
Yeah, but what
count. Do you think we'll
happened-
have a decision by then?
Yeah,
They'll be
absolutely.
hearing oral arguments
I mean,
on February 8th.
Look, this is either you will or you won't. But what the Supreme Court will surely do is to say you have to have two ballots. He's on one and he's not on the other if we can't decide the case before then. That's a very small alteration, but you can't possibly let the system run under the current situation. And then the Supreme Court says that the Colorado court is completely misguided. So they're going to have to make at least some adjustment. But then on the question of what's an insurrection, their definition is one of sheer madness. What they said, in effect, if you have two or more individuals,
They, meaning
in
the
the Colorado
Colorado
Supreme Court,
Supreme
the
Court.
four in the majority, right?
Right.
Two or more individuals who threaten or use force in order to determine the outcome of an election is engaged in essentially an insurrection. That means every time you had somebody in the Jim Crow era blocking black people from voting to change the outcome, it was an insurrection.
Under this definition, Peter, you've been an insurrectionist almost every 4
No,
years,
no.
going back a half century.
Yeah, but it's just crazy. You look at real serious insurrections. I mean, for example, I've been studying the Spanish-American War and insurrections lately. Don't ask why, but it doesn't matter. And it
Separate
turns
show. All right,
a
go
separate
ahead.
show. But what you do is you have a situation where we conquer the Philippines, take it away from the Spanish, and there was a full-scale insurrection out in the mountains with generals and soldiers and everybody
Right.
fighting. And so what happened, what McKinley said is, I'm going to tell my Secretary of War, Elihu Root, put down this insurrection. That's an insurrection. This is at most a riot. And it's not even that. This is
By the way,
basically...
could I also ask, just as a my legal knowledge goes back to Dartmouth College quite some time ago, but isn't
Which
it a
doesn't have a
basic?
law school, so how'd you get in?
Well, there was a great constitutional lawyer who taught con law at Dartmouth, even if we
You
weren't having
you
law
studied
school.
with Daniel Webster?
Almost.
You look like it.
Almost.
It's
almost.
a little college, but those of us who've been
All
there
right.
love it.
All right. Okay. Thank you very much. Enough of that. But the notion is that juries are finders of fact. This question of whether Donald Trump engaged in an insurrection has never been before a jury.
You're putting your
This-
finger on
correct.
a really important legal issue,
That was the
which also
dissent.
the court can use to escape.
This professor
Yeah,
likes
no,
me.
no,
There's
which
one.
is that
Go ahead.
the court could say the 14th Amendment, Section 3, does disqualify certain people for being involved with an insurrection, but it's up to Congress to implement it. When Richard just said, oh, the Colorado Supreme Court just made up its own definition of insurrection
It certainly
applied
did.
and applied to the facts of the case without ever having a trial where Donald Trump could appear and get due process and right to counsel, all the jury trial.
Yes.
So an important way that the court could, I think, escape having to make a decision is say it's related to Richard's political question point is this amendment is still good, it's on the books, and it's up to Congress to define what's an insurrection. It's up to Congress to decide how you prove it and so on. And until Congress does that, we, the courts, have to stay out. That's not a very dangerous thing to say. In fact, that's something the court regularly says when it comes to other provisions in the Constitution. It has to be executed by Congress first. And so then your point is going, Peter, there is an insurrection statute that Congress has passed. Donald Trump has not been charged with it. Despite President Biden's speech kicking off his campaign where he accused Trump of being an insurrectionist, where he accused Trump of attacking democracy, his Justice Department has not charged Trump with insurrection, even though there's a statute sitting out there. In fact, the only word we've had from any body of the federal government, whether Trump committed insurrection, is that he was acquitted of insurrection in the second impeachment trial. That's the only definitive word out there
They
right
did
now.
use the word in one of the articles of impeachment.
Right, incitement to insurrection. He was impeached for that by the House, and the Senate did not convict him on it.
onto the immunity case. May I
Yes.
go on to the second case?
You do whatever you want.
All right.
It's a
all
free
right.
country.
No, I just see that. I can see that you want to start telling us about the Spanish-American
No,
War.
I don't. I wanted to make this
I've got to
one
head
little-
that one off right
No,
away.
I'm not going to. I'll just make
By the
one
way, when
little
you
point.
No, okay. Make
When
the
you
point,
have
make
him
the
on
point.
for that
Oh,
show, I don't want to come. You can
One
talk
of the
about
one of the
that little
things
war
about
on
it,
your own.
what you're doing is talking about removal from office. It need not be a jury trial. It could be a trial in equity, which does not require juries. So, what John is right is essentially there are no procedures that are done in this particular case that are uniform. And so, what he's doing is a very clever move, saying Congress has to do this, and if Congress doesn't do it, then all the states are immobilized. The key point here is what the end result is. You need to get complete immobilization. This thing has to be out. So you can say, oh, Colorado was premature. They have to wait until T was put on the presidential ballot before you can remove him. That would be a disaster.
Okay. So they have, all right.
Before you move, I just have to, one more disclosure. I'm probably going to write an amicus brief at the court on this case. That's why I've been thinking about it a lot. So I just want to disclose that so it doesn't look
Well,
like
I mean, do you want to
secretly
if you'd like to
arguing.
make notes as we talk,
No.
if anything I say strikes you as worthy of the
Well, you
justice's
keep writing
attention.
that brief and I'll
Oh,
sign
I'm
it.
quoting you in the first paragraph now, Peter. You're in big trouble.